So yeah, there are three problem areas. And before I get into some of these details, one of the reasons that I really like estate planning law is it's one of the few areas where you can actually save people 5, 10, sometimes 100 times the fee that you charge. So it's just really fun also to be able to work with my dad, who I believe has an incredible amount of integrity and is very trustworthy. And it's just fun to be able to work with him. So it's fun to be part of the team. In terms of estate planning, to jump in, there's really three main areas that face Christian stewards in estate planning. Number one would be someone not of your choosing is making medical or financial decisions for you. We'll get into these in more detail. Number two, your estate is being distributed in a way that you did not envision. When I say estate, it's really everything that you own, after you're not around. And number three, lawyers, creditors, predators, and the government are reducing the value of your estate, what you've worked for. Whatever you have in the bank is you've made sacrifices to not spend it. So, it's just important to consider these issues. On the first topic, someone not of your choosing is making medical decisions for you. Does anyone know what happens if you're no longer able to make medical decisions? Well, taking a step back, does anyone know when legally you're no longer able to manage your own medical decisions, or when you're not able to make your own medical decisions? Does anyone know the standard, the legal standard? The answer is actually, it's determined by a medical doctor. It usually starts with a medical doctor certifying in writing that Ken Piercy no longer has the mind to make medical decisions for himself. And once they sign their physician's signature saying that, then I no longer have that ability. And I can fight that. I can get another doctor to go and argue with that, and then I can make that usually go away. But you need another doctor, and if they don't agree to that, then you can't make medical decisions for yourself. And that's when a lot of these problems can start to surface. So without documents in place, healthcare providers are prohibited by law to provide medical information to you, to anyone, even a spouse or a child. They're not required by law to provide that information. You could actually be stuck on life support for an extended period of time. Most people that I talk to don't want to be in a vegetative state for a very long period of time. Some people are like, give me a few days, give me a few weeks. Most people don't want to be stuck on life support for many years, depleting their assets to care for them in a vegetative state. So these are the issues that come into play. And that's why it's very important for everyone to have a power of attorney for healthcare. Has anyone heard of power of attorney for healthcare before? Good, got a lot of people hearing about that. So does anyone want to explain what that looks like, or what they think that is legally? Does anyone have an idea, since you may have them or heard about them?
Is it someone who you say can make the decisions for you?
That is exactly right. The answer is exactly what this lovely woman just said. You are appointing someone to make medical decisions for you when that event happens that you no longer can make those medical decisions. And you designate a person to make those decisions. You can identify the depth of care. You can prevent being stuck on life support. And it also resolves difficulties with living wills. Living wills basically are a document that state that if I'm in an irreversible state, I don't want to be kept alive indefinitely. The problem with that, with a standard living will, is you can usually get one expert witness physician to say they're in an irreversible state, and another expert witness physician say they're not. So the healthcare power of attorney is so powerful because the agent that you've named, that you trusted, usually a spouse or a family member or a trusted friend, they're going to listen to your wishes, and you can communicate with them, and you can create a written plan in this type of situation that avoids those problems that I just mentioned. And then there's also a federal law in all 50 states in the United States called the Health Insurance Portability and Accountability Act. And it basically restricts information from being distributed about you to anyone else. The idea behind it is privacy, but what that actually means is, when my wife was pregnant with our first child, I went to the hospital and they wouldn't tell me what was going on. So, because they don't know necessarily that we're not in the middle of a divorce or something. And so it's very protective information. Fortunately, we weren't, and I was able to resolve that issue. But it's very important to basically appoint, name people federally, all 50 states. These are the people that I authorize to be able to have access to my medical records. And you can actually make it so that it survives death. Oftentimes, you can make it survive, 30 to 50 years after you pass away. Just sometimes the family wants to know what happened so they can evaluate. Oftentimes the hospital won't provide the information to the family after death. Sometimes they're worried about being sued for a lawsuit, so they may not provide that. Or they're just leaning on the HIPAA, hey, we can't do it. So any questions about healthcare powers? Any scenarios that you guys might think of about healthcare powers? Yes.
So when you go to the doctor and they have you sign the HIPAA, whoever is your power of attorney, can see.
Great question. So when you go to the doctor, they make you sign a HIPAA release pretty much every time, and they usually are good for a year. And those HIPAA releases are very different than the HIPAA release I'm talking about. Those HIPAA releases are for the doctors and the health insurance companies so that they can get the information they need to properly bill you and get paid for the services. And it's drafted typically by a lawyer for the hospital or a lawyer for the doctor. They don't represent you. Totally different mindset compared to an attorney who represents you drafting a document designed to provide protection for when certain things happen. Does that make sense? Yeah. Great question. That's a great question. Any other questions on healthcare powers of attorney? Yes.
And this can be done for any adult from ages 18 and up.
Exactly. So the question is, how old do you have to be? When can it be done? And we recommend a healthcare power of attorney and a HIPAA release for everyone who's over 18, which is the age of emancipation under the law, the age of when you're considered a legal adult. Mentally, humans generally don't develop fully until they're 25 or 30. We'll get into that a little bit later. But you can sign a contract when you're 18, and that is when anyone who's over 18 should have these two documents, and we'll get into some of the additional documents.
Take the first step towards planning your legacy. Call 224-677-7711 or visit us online